Hi, I'm Jamie Johnson of the Johnson Law Firm, where we do estate planning and probate, and we do it well. Today I want to talk to you about what is estate planning. Now, when people usually hear estate planning, they think of mansions on 30-acre estates, on sprawling hills, multiple generational trust funds, millions of dollars. I can tell you that's a misconception. Estate planning is actually for the common middle-class family. Estate planning involves so much more than just trust funds and carrying money on for multiple generations. Estate planning involves powers of attorney, medical directives, your will, trust, all kinds of documents that protect you and your family to not only make sure that your assets are delivered to your loved ones on your passing, but also make sure that you're taken care of at the end of your life, or that your children are taken care of should something happen to you. Estate planning involves, of course, your traditional wills and trusts. Wills are documents that actually tell the probate court what to do on your passing, who to give your assets to. When you pass, your loved ones will provide your will to the court. The court will enforce the will, which means actually look at who you say to give your stuff to. They will make sure that your stuff is collected and then given to who you said to give it to. Then probate is closed. That's it. It's over. It's said. It's done. Trusts provide so much more control for you to make sure that your loved ones are taken care of. Also, trusts are commonly used to avoid probate, because probate can be a rather expensive, but mostly a time-consuming and just life-sucking event. Nobody enjoys probate. Even the attorneys that do probate don't enjoy probate. Probate can go anywhere from 9 months to 24 months. During that time, your assets are usually locked up and not able to be delivered to your loved ones. It can be a real pain. That's why we almost always recommend using a trust. Trusts are documents that are private contracts between you and the trustee, where your assets that you have placed in the trust are delivered to your loved ones in a quick and efficient manner. It's efficient both financially and it's efficient time-wise. It's much, much preferred to probate. So now we've covered the wills, the trust, what is also included in estate planning. A power of attorney. A power of attorney is where you name someone to help you out and be in charge of your assets and your legal matters should you become incapacitated, either physically or mentally. Now, we call this a springing power of attorney because it requires the actual event of you being declared incapacitated in order for that power to be granted to the person you've named in there. Otherwise, it's considered to be what we call a general power of attorney. And with the general power of attorney, as soon as you sign that power of attorney, you're granting that power to whoever you've named as your agent. So we usually recommend the springing power of attorney as opposed to a general power of attorney, unless, of course, you're naming your spouse as the primary agent. So power of attorneys cover your legal rights and assets and finances, things of that nature. But in Virginia, we have what's called a medical directive. A medical directive is where you're naming a power of attorney over your healthcare decisions. You're granting someone authority that should, again, you become incapacitated either mentally or physically, then you're saying, I want this person to be the person who I trust to be the one to be in charge of your healthcare decisions. Now again, this power does not spring into effect until after you've been declared either physically or mentally incapable of making decisions yourself. Finally, we have what's called a HIPAA release. With the HIPAA release, our Congress, you gotta love Congress, with the medical directive only grants authority to make decisions, does not grant you authority to have access to the medical records and medical history of the person that you're making decisions for. So we include the HIPAA release to go along with the medical directive. That way, if someone's gonna make a decision for your health care, they're going to have access to your medical records and your medical history as well, so that way they can discuss that with the doctors. Otherwise, that information is protected by law. Doctors can't discuss it with your agent. Your agent is left trying to make a decision with you with incomplete information. So as you can see, estate planning can be all-encompassing and something that is very important to lots of different people in different stages. We recommend that if you have children, you need to have estate planning done. You need to make sure your children are taken care of. You need to make sure that decisions are made how they're going to be provided for, but also who's going to make decisions for you. When your children get older, when they become college-aged, then you might want to revisit your estate planning, because at that point you don't necessarily need to name a friend or your sibling who lives a couple states away. You can name your adult child who you trust to make decisions for you. If you have any questions about estate planning, please reach out to us at Johnson Law Firm. We're happy to answer them for you.